Hi madam, I'm Dashani. Today I'm going to talk about a case study called Para Integrated Network Service Sdn Bhd and Urban Domain Sdn Bhd as rule on the issue of whether a common law derivative action can be initiated where the company is in a 50-50 deadlock. Let me look at this case further. In 2005, the company Para Integrate was granted a license by the Malaysian Communication and the Multimedia Commission. In 2007, Urban Domain and Para Integrate formed a separate company called PINS. The shareholdings of PINS was 50-50 split between Urban Domain and Para Integrate. The board of PINS was also only 2 directors, each director appointed by Urban Domain and Para Integrate respectively. What happened next? Urban Domain claimed that PINS was due additional rental proceeds and other payments from various telecommunication providers. In March 2011, Para Integrate took over all the books and accounts of PINS. After that, in July 2012, Urban Domain filed a derivative action on behalf of itself and PINS. As we know that members can bring an action on behalf of the company. What is Urban Domain's allegation? Urban Domain saying that, hey, Para Integrate and the nominate directors of PINS, you guys made losses and damage, suffer for our company. So I want to sue your company and also the nominate director. I see you guys in the court. After a full trial at the High Court in 2013, Urban Domain claim was allowed against Para Integrate. Furthermore, in 2014, Urban Domain filed a petition saying that, oh my god, we can't continue this company anymore, so we're going to winding up PINS. But later, the petition was not allowed. After a court of appeal, Para Integrate Council raised voice for preliminary issue on whether the suit was a properly considered derivative action. Later, the court dismissed this preliminary issue. The Court of Appeal held test to estimate Longdor's control for a derivative action is one of the de facto control, and that being a majority or minority shareholder, it's not conclusive. Longdor's control could be satisfied in a deadlocked company where the shareholding is split 50-50. What is Federal Court decision? Federal Court made a decision. First of all, they analyzing the history behind derivative action. Where wrongdoers are in the control of the company, such the company cannot bring an action, the court allow an action to be brought by the individual shareholder on behalf of the company to obtain redress. In this case, the argument was whether it could be said that company was in the control of Longdor's. The requirement of Longdor's control is satisfied if it can be shown that company is practically incapable of bringing an action against the Longdor's for its benefit. Next, the Federal Court considered the interplay between derivative action and a just and equitable winding up petition. It was held that the availability of the alternative remedy of winding up in a deadlock scenario would not prevent a shareholders from pursuing a derivative action. Finally, the Federal Court saying that, okay, just refer to a certain English cases where the derivative action was not allowed as a company were already in liquidation. After they refer one by one, a factor saying that once the company was in the liquidators, the necessity for a derivative action disappeared. It could not say that minority shareholders was at the mercy of majority. The liquidator could be asked to bring an action in the name of company. If the liquidator is unwilling to do so, relief could be obtained from the court. Moreover, the Federal Court has also adopted the case law that has held that the common law derivative action cannot be sought once the company is in the winding up. It is very likely that the similarity principle would apply for the derivative action, such there cannot be derivative action once the company is in the winding up. This is consistent with the Singapore Court of Appeal case in Petroship Investment as well as other case law from the UK and Australia. That's all from me. Thank you.